So welcome everyone to the 2020 Stanford University Constitution Day celebration, our first ever done virtually and first ever done in the midst of a pandemic. So we are making a history here. My name is Michael Mcconnell. I am the director of the Constitutional Law Center at Stanford Law School, and we are charged by the university with the university's responsibility to provide a commemoration of the anniversary of the not the adoption, actually the anniversary is of the completion of the Constitutional Convention back in 1787. So that was what if my arithmetic is correct, that was some 233 years ago. And that achievement still endures in many respects. But one of the ways in which the Constitution was obviously deficient was in its mechanisms for democracy. It's really very sketchy. This being the first large republic in the history of the world, they really didn't know exactly what they needed to address. And one of the things that was not really addressed was who could vote. So the original Constitution provided that in federal elections, the same voter qualifications would apply as for the most numerous branch of the state legislature. So this is all over the map, different voting qualifications in different places. And we know that this was a deficiency in the Constitution. That's not just my opinion or anyone of today, but it's because there have been no fewer than 6 constitutional amendments since then addressing and in each case broadening the franchise. So, and we are here celebrating today not just the 233rd anniversary of the proposal of the original Constitution, but also this year is the 100th anniversary of the 19th Amendment, which is the amendment that added to the Constitution the prohibition on discrimination on the basis of sex, so giving women the right to vote. Now, to some extent, in many states, women had the right to vote even before the amendment, but it made it a constitutional right and a nationwide right. And so we thought it was appropriate this year to devote the Constitution Day lecture and celebration to the 19th Amendment from 100 years ago. And who better to address that than our guest this evening, Judge Margaret Mccann. Now she's a judge on the United States Court of Appeals for the Ninth Circuit, where we are, and she has been on that court since 1998. I could recite all of the details of her background. She's a notable first in many ways. She was the first woman partner at the largest law firm in the Northwest. She was the founder of that law firm's intellectual property program. She's a member of the ALI. She's just recently was elected a member of the American Academy of Arts and Sciences. She is well known, especially on the court, for her work in technology and also in gender issues and others. But I would rather just add a personal note or two, because we were just before the program, we were reminiscing, and we met. We were introduced by a mutual friend of ours back in, I think it was the winter of 2000 to 2001, when we were both skiing at Park City. Now I was clever enough to find a way not to have to actually ski with Margaret, because I would have both held her back and gotten personally embarrassed in the course of that. She is an outstanding outdoors woman, not just skiing, but I think maybe the most interesting detail of her biography, which Morgan Weiland just told me about a couple of days ago, a former clerk of hers who is now the executive director of the Conn Law Center. Morgan was telling me that Judge Mccann survived an avalanche on a mountain, an almost 27,000 foot mountain on the border of Nepal and Tibet, where she was the first woman who was a member of the American expedition to climb that mountain. That must have been quite an experience, Margaret, to do that. She was born in Wyoming. She continues to travel and ski and enjoy the outdoors in the American West. So she's going to speak to us this evening on the 19th Amendment. I love the title of her talk, "My Mother Made Me Do It: How Motherly Advice Secured Ratification of the 19th Amendment and Changed the Course of History." She'll be speaking for however long she wants, but probably about 40 minutes or so, and following which there will be time. She's agreed to take questions. You should formulate your questions and send them to Chaz Tyler over the chat function, and then he will be taking the questions roughly in the order in which they come. So please be thinking of questions and sending them during the course of the talk. And so without further ado or complication, please join me in welcoming our speaker for the evening.
Good afternoon. I can't tell you how much I wish I were sitting or standing in a lecture hall at Stanford to talk with you, but it's not to be. So I thank Professor Mcconnell for that very nice introduction. I did indeed survive an avalanche, and I'm happy I did for a lot of reasons, but one of which was I could later then ski with Mike over in Utah. As he said, the short title of my talk is "My Mother Made Me Do It." But since this is a statutorily mandated lecture, I probably should say Professor Mcconnell and the US Congress made me do it. But I'm very excited that we can celebrate this Constitution Day with the 100th anniversary of the 19th Amendment. For when the Constitution was drafted, it was written by, for, and from the perspective of men. You may recall that Abigail Adams presciently said in 1776, "Remember the ladies." And it's no surprise that Hamilton, the musical, includes these lyrics from the song, The Schuyler Sisters. Now I'm gonna save you, and I won't sing, but I'll relate the lyrics to you. Here's what they said. "We hold these truths to be self-evident, that all men are created equal. And when I meet Thomas Jefferson, I'ma compel him to include women in the sequel." Well, that sequel took about 150 years to write, rather laborious, and it came about with the 19th Amendment, which was ratified in August of 1920. Amazingly, that fight lasted for 7 decades and 3 generations. Many of the women who started that fight, of course, were dead by the time it went across the finish line. And many of those who brought it across the finish line weren't even born at the beginning. So it is a story of race, class, money, gender, and states' rights. In our brief time together, I want to explore what it took to achieve the amendment, the importance of the Western states in this endeavor, some of the anecdotes in between, and then briefly close with the significance of the amendment today. Now, rather than starting at the beginning, I'm going to start at the end. First, a couple of semantic points. If you were there in person, I would give you this quiz. Which is correct? Suffragists or suffragettes? Well, the answer is suffragists, because those against the amendment used this diminutive term, suffragettes, to try to belittle the fight. And a second point, sometimes it's said that women were given the right to vote, as if it were some kind of gift wrapped up in a little package and tied with a ribbon. But make no mistake, women fought for this right, and the right to vote was not a gift. So let me take you now to that summer of 1920. The amendment was either on the brink of ratification or extinction. There were 35 of 36 required states. Many states had already rejected it, and there was a margin of only 5 possible states left. And several in the South were just non-starters. So suffragists believed that Tennessee was their best hope. In fact, it was North Carolina and Florida actually waited another 50 years to ratify the amendment. So the strategy was a lot like looking at a very narrow electoral map. Pick a winning target and go for it. Fortunately, the governor of Tennessee, Roberts, supported the amendment, so he called a special legislative session, and thousands of suffragists and antis, that's what they call those who are opposed to the amendment, they made this pilgrimage to Nashville. The rhetoric was heated, and one broadside is particularly memorable to me. Here's what it said: "Men of the South, heed not that song of the suffrage siren. Seal your ears against her vocal wiles. Do not jeopardize the prosperity of your sovereign states." Now, at the time, leading the fight for the National Women's Suffrage Association was a woman named Carrie Catt. And she made a long train trip from New York to be there to participate in the final strategy. The year before, she went on what she called a Wake Up America tour. And that was an effort to try to start a nonpartisan League of Women Voters. And eventually, of course, we do have and still have the League of Women Voters. So she holed up in what was called the Hotel Hermitage. Now, women could not enter through the front door without a man. And though she was relegated to a side door, she was front and center of all the political strategy. It was pitched as a battle between good and evil. And at the time, legislators were getting these late night phone calls threatening them professional, financial, and political ruin. In the spirit of the day, some accepted bribes. And it was what I would say backroom politics at its best or worst, depending on your perspective. Now, the opposition had a very clever strategy. Those with a weakness for whiskey were invited up to what was called the Jack Daniels Suite, also at the Hermitage Hotel. And the hope was that they would get liquored up and their hangovers would be so brutal that they wouldn't show up for the roll call vote. Until that vote, of course, Hermitage Hotel was strategy central. And the distillers were totally apoplectic about the amendment because they were afraid that if the amendment passed, women would be in favor of prohibition, which was not an unfounded concern. So it easily passed the Senate and ran into kind of a buzzsaw in the House in Tennessee. So they tried to table it. One of the votes favoring tabling was the youngest member of the legislature. He was named Harry T. Byrne. He showed up in the chamber and he had on his lapel a red rose. What did that mean? That meant he was opposed to suffrage. But he also had in his jacket pocket a letter from his mom. Here's what she wrote to him: "Hurrah, vote for suffrage, don't keep them in doubt." And then he said, "I noticed some of the speeches against, and they were bitter, but I've watched to see how you stood and have not noticed anything yet." So she ended her letter with a nod to Carrie Catt, and she said, imploring him, "Be a good boy. Help Mrs. Catt put the rat in ratification. With lots of love, Mama." Well, the mood was pretty hostile. Some legislators fled the state to avoid a quorum, and that turned out to be futile. The rallies were intense, but in the end, Harry did the right thing. He took his mother's advice and voted yes. So with that, Tennessee delivered the crucial 36th state. So it came to pass that this I vote of one 27-year-old man helped enfranchise 26 million American women. It was the largest democratizing event in US history. His vote, of course, came on the tail of decades of tireless campaigning. The path began actually in New Jersey. And amazingly, the New Jersey Constitution granted all inhabitants of legal age who met property and residency requirements the right to vote. And in the state election law, it used the words he and she. So everyone was pretty excited and women were able to take advantage and regularly vote. But there were allegations of voter fraud. And before long, in the end, something worse happened than voter fraud. The New Jersey legislature withdrew women's right to vote. So now let me take you across the country to the West. So although New Jersey ended in failure, the real action was out West. You may recall that musical, How the West Was Won. I think the rallying cry should have been, How Women Won the West. So as early as 1869, women in the West had the right to vote. As Professor Mcconnell said, I am a native of Wyoming, a proud native of Wyoming, and I'm happy to share that state's story with you. The Wyoming Territory was the very first to secure the right to vote for women. And I have to say the high ideals of suffrage were not necessarily on the table. The reality was, think back to the late 1800s, Wyoming had the largest gender imbalance in the whole country. For every 100 males, there were only 58 females. So lawmakers thought, well, if we give women the right to vote, maybe they'll come out into the territory. So it was an early version of increasing the population and paying lip service to every vote counts. What was interesting is that this tactic of giving women the vote actually flipped on its head the concurrent push that was going on the other side of the country. Northern states were actually imposing Black suffrage on the South, but not because they really wanted Blacks to vote, but they feared there would be a Black migration northward, which of course eventually happened. Now, many lawmakers in Wyoming thought it was only right that women, and in particular white women, should have the right to vote. After all, Black men and Chinese men, at least in Wyoming, had the right. And so one newspaper even said, you know, that was the clincher. Those were the principles they were operating on. And some even thought the voting bill was a joke. One legislator called it the greatest hilarity we've seen. Now, at this time, Wyoming is a territory. And on their mind was the question of statehood. But to get into the state, you need a certain population. And so if you could get an influx of women into the state, then Wyoming could meet those numbers and become a state, which it did in 1890. So it was really the Wild West out there. Another motivating factor is that there was a view that maybe if women came out west, it would kind of elevate the morals of the territory, which were nothing to write home about at the time. So whatever the motivation of the legislators, Wyoming was pretty steadfast, and it took its place as the equality state in 1890. It later went on to embrace women's equality, voting, jury service, and public office. Interestingly, it was home to the first female governor, Nellie Taylor Ross, first woman appointed to public office, Esther Hobart Morris. You can see her statue in Statutory Hall in Congress. And it was the first town governed totally by women, Jackson Hole, Wyoming. So when Wyoming applied for statehood, Congress recoiled because they did not want a state to come into the Union giving women the right to vote. But fortunately, the Wyoming legislators said, we'll stay out of the Union for another 100 years. unless we can bring the women with us. Finally, Congress relented, Wyoming became a state, and they were soon joined by some other states by the turn of the century, Utah, Colorado, and Idaho. And then by 1914, 7 more states, including California, granted suffrage to women. So now let's flip back to the East Coast. For whatever reason, women's suffrage was really having trouble taking root in the legislative route, although there was really a vibrant advocacy community among women. So there were a couple of women whose names we now remember, Lucretia Mott and Elizabeth Cady Stanton. They organized what has now become the famous Seneca Falls Convention, the year 1848. 300 women and a number of men showed up, and they were talking about social, civil, and religious rights of women. They created at the end of the conference what they called the Declaration of Sentiments. And it looked a lot like the Declaration of Independence, except there was one very special sentiment. It was a number 9, and all the resolutions passed except the 9th. And that related to the elective franchise. Some women felt, well, that was just a bridge too far. You can have equal rights, you can have all these other things, but voting? No. So it was interesting because Stanton was very strong in favor, of course, and another supporter came from a very different quarter, Frederick Douglass. He started giving speeches, and in the end, there was a call to action to say, we're going to enlist the press, we're going to enlist the pulpit, but we will get the vote for women. And so finally, that call of action proved very inspiring. According to Judith Wellman, who is an historian of the convention, she said the Declaration of Sentiments was actually the single most important factor in spreading news of the women's rights movement across the country, not just that year, but into the future. Now, of course, we know from history that wealthy white women were often the face of the suffragist movement. But that actually belies the breadth of inspiration and support from other communities. For example, Mott and Stanton benefited greatly because they had had a number of interactions with the tribes, the 6 tribes of the Iroquois Confederacy. And it's interesting because that confederacy was one where women participated in all major decision-making. For example, they had the power to veto acts of war. They had the power to choose and remove chiefs, and they controlled land and resources. So recall that when the early European settlers showed up to what is now the United States shores, they had to negotiate with the Iroquois tribes involving land, and that had to be approved by women. So you had the Native American tribes in support, and then suffragists wanted to look to all quarters. So they looked to one of the most influential women's groups, the Women's Christian Temperance Union, the WCTU. And that group had sought to combat the effects of alcohol abuse on women and children. Because women were just chattels, they had no rights, the temperance supporters recognized the scourge of domestic violence. And believe me, there was plenty. So when they got a new president in 1789, Francis Willard, they expanded their platform to include not just suffrage, but also labor law and prison reform. Of course, Willard said, once you give women the right to vote, they will purify politics. Well, that was wishful thinking, as we know. But the reality was there was kind of this delicate balance between the suffragists and the prohibitionists, because each needed the other to a certain degree. The suffrage movement also had support from the abolitionist quarter. Now, Frederick Douglass was a true suffragist, and he actually was given the moniker, the woman's rights man. He published an editorial in an anti-slavery newspaper called the North Star, and he said in such very simple language and so eloquent, in respect to political rights, there can be no reason in the world for denying women the elective franchise. So along with Frederick Douglass, there were a growing number of Black women like Ida B. Wells Barnett and Sojourner Truth that supported suffrage. But interestingly, they viewed suffrage as a means to rectify oppression in their marriages, that is, the white women. But African-American women viewed it a little differently. They viewed it more as a way to overcome racism and sexism. And as the NAACP recognized in some of its publications, if white women needed the vote to protect their rights, Black women needed it even more. So then we came, of course, to the Civil War. And after that, the ratification of the Reunification amendments. Those breathed new life into the suffrage movement. Activists had this idea that maybe the 14th and 15th Amendments could be valuable for litigation and advocacy. After all, listen to their language. States were prevented from denying, quote, any person within its jurisdiction the equal protection of the laws. And it also prohibited states from withholding the right to vote on account of race, color, or previous servitude. Well, the reality is the amendments protected men of color and not women. And so at the time it was said, it is not the woman's hour. Hear me out. It was not yet the woman's hour. And that became the title of a very wonderful book on the history of the 19th Amendment written by Elaine Weiss. So now we have the first presidential election following ratification of the 14th and 15th Amendments. And Susan B. Anthony, who we all know, we've even seen her on a coin, she was one of the founders of that group that Kat later was the president of. And she decided, well, this was a perfect chance to challenge these laws. And she turned to the 14th Amendment's Privileges and Immunities Clause. That clause reads in very straightforward terms, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Women were citizens back in the 1800s. And the Fourth Amendment said no citizen should be denied these privileges and immunities. So Susan B. Anthony said, there go, women should get the right to vote. Well, if it were only that easy, and of course we know it wasn't. So here's what happened on election day, pretty interesting. Somehow Susan B. Anthony and her followers somehow persuaded the election inspectors to let them pass, and they went to the polls to vote. They were then arrested and charged with illegal voting. So for Anthony, she thought, great, I think that this is a great opportunity for women's suffrage. She knew her trial would be in Monroe County, New York, so she went up there and she gave a speech. Here was her speech, and she knew the jury pool would come from there. She said, is it a crime for a US citizen to vote? Now, that title actually has a familiar echo today. Her efforts were thwarted when the government said, well, let's move the trial to a different federal circuit court, and it sat in a different county. Anthony was not defeated. She simply went over to that county and started giving speeches there. So essentially a year after her arrest, they had the trial. And by then the Supreme Court had decided several cases that basically said that rights under the 14th Amendment are quite narrow. We refer to those as the Slaughterhouse Cases, and then the case of Bradwell versus Illinois, which said, of course, a woman could not be a member of the bar, could not be a lawyer. So the bottom line with these amendments is women weren't included. Guess who the judge was? He was a justice, actually, of the United States Supreme Court, but he was riding circuit. So he was the judge, and in his view, Anthony knew she didn't have the right to vote, and she acted knowingly, so he thought she was guilty right off the bat. Amazingly, he didn't even let the jury deliberate. Instead, he directed the jury to return a guilty verdict. So in my mind, this was like reverse jury nullification, only it was engineered by the judge, or in this case, the Supreme Court justice. Now, at the time, Anthony could not have testified at her own trial, but she did have an opportunity to speak at her sentencing. And when the judge said, "Do you have anything to say?" she said, "Oh, I have plenty to say." So she started, and over the judge's admonishments, she said, he said, "Sit down, stop talking." He realized he'd opened the door. Here's what she said. She said, "This trial is a high-handed outrage on my citizens' rights." And then she went on to argue, "You've trampled underfoot every vital principle of our government. My natural rights, my civil rights, my political rights, my judicial rights, all alike are ignored." Well, all of that fell on deaf ears, as you might imagine, and she was ordered to pay $100, at which point she piped up again and she said, "I shall never pay $1 of your penalty." And she didn't, because her lawyer ended up paying. And you may have heard that she was recently granted a pardon in 2020. Now, that election was notable for another reason. It was the first time there was a female presidential nominee. She ran as the nominee of her own party, the Equal Rights Party. And she was a big supporter of the suffragist movement, and she felt that the 14th Amendment should give her a right both to run for office and also to vote. But she also saw herself as a feminist, and she said it's not just the right to vote. She wanted sexual, societal, and economic liberation. But she was also, I would say, fairly perceptive about her situation, because she said, "I know that I'll get more ridicule than enthusiasm by running, but it's an epic of changes and startling surprises." So she ran anyway. By the turn of the century, we had Kat, the woman whose Burns's mother had invoked in that catalytic letter, and she was president of the National American Woman Suffrage Association. So she had a new plan and a new strategy. She called it the winning plan. And what it meant was she wanted to incrementally go out, and for the states that had already passed suffrage, she wanted to focus on the 19th Amendment. And for the states who had not, she incrementally wanted to go to legislatures and get them to pass within their state. And very importantly, she really presciently realized that the association should work to elect men who would support their cause. Now, things were not all milk and honey in the suffrage movement. There were other factions that were much more combative. And while they were working to the same goal, they were not necessarily using the same strategy. Two of those who were considered in the more radical end of the movement, Alice Paul and Lucy Burns, well, they got their education through the British suffrage movement and were in London advocating, and they were arrested multiple times. And in fact, Paul was imprisoned 3 times for her activist work. So then they moved back to the US and they joined a different faction called the National American Woman Suffrage Association. They were getting a lot of pushback from some of the others, so they decided, why not turn your sights on Washington? So they organized the first Women's March, 1913. And they wanted to march in the spirit of protest against the political organization of society. And they also thought that it was important to refocus the suffrage movement to keep their eye on the 19th Amendment, and also to put pressure on President Wilson. He was no friend of the 19th Amendment. So believe it or not, the march actually attracted 5,000 to 10,000 participants, and there's not even a doubt about that. And they faced heckling, intimidation, and hostility. You'll also see women suffragists marching in front of the White House, something really unheard of at the time. And they often wore white dresses, you know, with a very high collar and then a yellow sash. But even with all of that, President Wilson managed to evade the suffragists for years and years after. However, what the suffragists could not have known and would not foresee at the time was that two catastrophic events, World War I and the pandemic of 1918, would actually help their fight in a positive way. Turns out Kat herself was stricken by the flu, the pandemic, but she knew that at this point, coming through the war, that the movement could strategically redefine what was the role of women in society. So it swept in a whole new rallying cry. Women replaced men in the labor market, of course. And so they argued, well, we should have the right to vote. It's hypocritical to be defending democracy overseas and abroad and to abandon it at home. So they seized the moment, and we all know that they filled very critical jobs, manufacturing jobs. They were out in the fields, in the farm fields, and of course they served as nurses on the front line. And they became the glue that held American society together. By this time, the time of the pandemic, 1918, 15 states had given women the full rights, and some had offered partial rights. But President Wilson, no political fool, he was facing a very contentious midterm election. And so with his teeth clenched, I think, and his fingers crossed behind his back, he voiced his support for the 19th Amendment. And he said, well, should we just admit women to partnership of sacrifice and toil and not to a partnership of privilege and right? And then he enthused in a letter to Kat, the services of women during the supreme crisis of world history have been of the most signal usefulness. And he admitted the war could not be fought without them. So it may have been political expediency at its finest, but then who are we to eschew positive results? So now we had a welcome victory in World War I and another catastrophe. In 1918, the influenza pandemic was spreading, and suffragists had to confront the ban on public gatherings. So what happened? They canceled marches, they canceled rallies, they canceled parades, soapbox speeches, but it didn't mean they canceled the movement. It just meant it would look different. So in a lot the same way where we are with COVID-19, and it's changed how we use the internet, Zoom, and other platforms, how we connect with our family and our friends, communities, how we hold court hearings. All of my court hearings, of course, are virtual hearings, how we continue business, and how candidates run and conduct their campaigns. So in the same way, the suffragists shifted their tactics. Remember, they didn't have radio and television. So interestingly, in another parallel to today, they turned to the US mail. They also turned to telephone calls, posters, banners, and news advertisements, and even cartoonists. If you go back and look at some of the books, there's some fantastic suffrage cartoons. One I particularly love is a couple of little babies, and it says at the top, "Babies, give mother the vote. We need it. Our food, our health, our play, everything's ruled by the man's vote." So they really used every possible vehicle they could to get out the word. And the suffragists were very strategic and political. One of the best examples was the publication of cookbooks. And I have to say, I now have FedEx at the door, and I'll just have to say goodbye to him. To gain support, they published about a half dozen cookbooks The first one was in 1886, and the editor called the cookbook Our Messenger, and he believed it would serve as a blessing to housekeepers, and it would be an elevation of the enfranchisement of women. Interestingly, there's a double entendre here, because it meant the women could be in the kitchen and with their families, and it also meant they could be out on the campaign trail. So they raised a lot of money and combated the image that suffragists were unfeminine and were poor wives and mothers. I've had the privilege this year to chair the ABA Commission on the 19th Amendment. So we had this idea of why not, in the spirit of the suffragists, have a cookbook. So we published, and I'll show you a picture of the front cover, and later I'll show you the slide with the address. We published the 19th Amendment Cookbook, 100 recipes for 100 years. And we recognize that COVID has dramatically changed how we're interacting. And many people are at home and they're actually cooking and they're sharing food. So the book includes recipes from legal luminaries, 5 Supreme Court justices, international jurists, federal and state judges, lawyers, and the media. But best of all, it's digital. And in the spirit of sharing, we made it free to download. You can go to 19thAmendmentCookbook.com and you can download it for free. And if you go there, you'll find a recipe for pot roast, for example, from Justice Breyer. If you're into more complicated and tasty recipes, you can look at those by Justice Ginsburg's husband, Marty, who really was the supreme chef. She doesn't cook. Or you can go to a green chili recipe from Justice Gorsuch, or a handwritten recipe from Justice O'Connor's little recipe box, or fast and easy dressed up fish from Justice Sotomayor, and even the original Girl Scout cookie recipe. In a great both coincidence and happy event, you can also see in the back burner column, Florence Fabricant in the New York Times, she featured the cookbook today. Now, all these efforts, marching, mailing, cookbooks, and speeches paid off. And central to the success was a coalition building. So even groups that had just a passing interest in voting and urbanization and the confluence of the war and pandemic brought the amendment to fruition. So we can take the slide down now, please. Finally, President Wilson bent to the pressures of the suffragists, and he called a special session of Congress. June 4, 1919, the amendment passed Congress. And amazingly, it was just a year later in August that it became part of the US Constitution when Tennessee voted to ratify. This is a dishearteningly, when you contrast it to the Equal Rights Amendment, which did not reach ratification even after a 7-year period and a 3-year extension. So then you have to ask yourself, well, what does this mean, the 19th Amendment and the fight for equality? The truth is, following the amendment, there were many challenges in the coming years. There was low voter turnout by women. Only about half of them voted in that first election. And until the 80s, women voted in lockstep with their husbands or those in their household. There were barriers to Black women's voting, discrimination against Native Americans, Hispanics, Asians, and other populations. And there were protracted legal battles. So the amendment was just the beginning of a much longer struggle for women's rights. And it did not bestow on women all of these privileges that had been granted to men. Now that said, in my view, the amendment has both meaning and vitality outside of that monumental event in 1920. So I take issue with Justice Harlan, who said in a dissent in 1963 in a voting rights case, he said, the amendment merely gives women the right to vote. I suggest it isn't merely, but it does a lot more. For example, the amendment offers an important lens on how to think about women's equality. It was a springboard, really, for an effort that continues today. There's never been a straight line to victory for equality, whether women's equality or equality for others. Even after the amendment passed, the Supreme Court rejected the idea that women could serve on juries. And as I mentioned, it had already concluded way back in the 1800s that women couldn't become lawyers. So they couldn't go to the bar, and they couldn't even become bartenders, as the Supreme Court ruled in 1948 in a case of Gossett versus Cleary. So even today, the court battles are fought over the Equal Protection Clause and how it applies to sex discrimination. Justice Ginsburg reminded us in the case of United States versus Virginia, that was the 1966 case in which the male-only admissions policy of the Virginia Military Institute was struck down. Here's what she had to say. A prime part of the history of our Constitution is the story of the extension of constitutional rights and protections to people once ignored and excluded. So the amendment was, in fact, a springboard, not a closed door. Another thing is that the amendment also provides an historical understanding of the role of women in society and the role of women vis-a-vis the American family. According to Reva Siegel, a professor at Yale Law School, this understanding should inform the way that courts and legislators think about regulation of pregnancy, contraception, sexual violence, and federalism. And finally, the amendment should be considered against the backdrop of its time. What was the main purpose of the amendment? It was to protect against the subordination of women in US politics. So today, it is more than just a right to vote amendment. The amendment says it relates to both denial or abridgment of the right to vote. And interestingly, this right to vote language is found in 5 different constitutional amendments: the 14th, the 15th, of course the 19th, the 24th, and the 26th. And those amendments need to be read together synthetically and holistically. Together, they serve as a foundation to promote political equality in voting and to remove barriers to voting. Earlier this year, the ABA Commission partnered with Georgetown Law Journal to produce a special edition of the journal, which includes a conversation between Justice Ginsburg and with me on what the 19th Amendment means. But it also includes very important scholars from the Academy talking about what is the meaning of the amendment as we move forward. So despite the many advances, discrimination on account of sex remains a challenge. Imagine that today, the United States is the only high-income developed country without a national paid family leave law. Although, fortunately, as of 2020, some and many federal workers will get those benefits. It's also one of only 7 countries that has not ratified CEDAW, that is the United Nations Convention on the Elimination of Discrimination Against Women. That commits to ending gender-based discrimination. And amazingly, and I'm always surprised by this, the World Economic Forum ranks the United States 65th in wage equality. And the list goes on. So women have a long way to go. But nonetheless, the amendment was a very significant milestone in establishing women's equality. As our good boy Burns later explained when he had to defend his aye vote to the Tennessee Assembly, he said, "I believe we had a moral and legal right to ratify. And I know a mother's advice is always safest for her boy to follow. And my mother wanted me to vote for ratification." I appreciated the fact that an opportunity such as this seldom comes to a mortal man to free women from political slavery. Amazingly, this is the same guy who wore that red boutonniere on his lapel opposing the 19th Amendment. He came a long ways with his mother's counsel. So in closing, my hope is that we can remember the heroic efforts of our mothers, our grandmothers, and our great-grandmothers, along with the courageous men who supported the cause along the way. And I also hope that this anniversary inspires us to work toward a better and more equitable future. Just remember, it pays to listen to your mother. So in closing, I'll tell you, stay positive, test negative, and thanks for joining us today for this Constitution Day lecture. And though I can't see you at all, I know you've been a great virtual audience. So with that, I will turn it back to Professor Mcconnell, and thank you for tuning in.
Thank you. That was wonderful. And we do have time for questions from all of you. I know that some have already been sending them into Chaz, and I'm going to turn it over to him to field the questions.
Thank you very much. That was breathtaking. So the first question we got is, can you discuss the importance of the appointment and confirmation of Constance Baker Motley and the pressure that still accompanies many women and women of color for being the first of anything, especially on the federal bench?
Yes, well, she was first African-American appointed to the federal bench, and she had a very long and distinguished career before she went to the bench working on civil rights legislation, and then she distinguished herself while she was on the bench. I think it's always a challenge to be first, but I have to say she acquitted that role so well in that I think she was able to leverage being first, but she didn't lord it over either those who are her colleagues or those in the American public. And she really came to be recognized as a real legal force. We have seen through statistics that, and this is not related currently, but over a long time, I think it's the Brookings Institute that has done these studies that show that confirmation, nomination of women and minorities has been fraught with delay and controversy.
So someone writes that they learned that there was a powerful anti-ERA movement among women, and they wonder whether there was an analogous movement against the 19th Amendment among women, and if so, if not, why not? And if so, why did one movement succeed and the other didn't?
Well, that's a really interesting question. There were women against the 19th Amendment. They were called the antis also, and really they streamed into town once it was learned that the legislature would be voting. So why were they anti? Well, there were a lot of reasons. Some were threatened and they felt it would upend their domestic life. Others felt that men really represented them already in the American electorate, so why did they need the right to vote? And others also felt it really wasn't ladylike or feminine to be out there demonstrating and pushing for something like this. So the antis were out there, and they were out there also in, of course, the ERA movement. And I believe that really one of the most famous, Phyllis Schlafly, about whom there's recently been a movie, was one of the most articulate. She's a very accomplished woman in her right in terms of being a lawyer, being articulate, and being a very vocal force. Why did the ERA fail? Well, that is hard to say, except that I think by the time you get to the late 70s and the early 80s, it's a very different time. And as I said, there was this confluence of events, which often is how things happen politically, that really came to push the 19th Amendment across the line. They'd been at it for 7 decades. Now, there was an Equal Rights Amendment that was introduced, not long after the 19th Amendment, but it kind of floundered. So the true Equal Rights Amendment being introduced wasn't until much later. But when you had such momentum by the pro-suffrage forces, they were hard to beat down, and they had a really important point. And by the time they got to World War I, they had really an incontrovertible point. We did everything but fight in the battlefields. We went to the battlefields. We were nurses. We kept the farms running. We kept the factories running. And how is it you can actually deny us the right to vote? So I think there was a lot of pressure. And to be honest, President Wilson, who had not been a supporter, kind of, got the light. And that was very important to get presidential support. So I think that was really important. By the time you get to the 70s, some people said, well, why do you need an Equal Rights Amendment? A lot of states passed their own Equal Rights Amendment. Isn't that enough? And why do you need a special amendment for women? Women can be protected through the courts and the Equal Protection Clause. So there were a lot of arguments against it. But again, I think I was actually involved in litigation regarding the ERA extension. All of that came for naught because the time passed and the Supreme Court declared it moot. But I might say another thing is that getting a constitutional amendment passed is really, really hard. So there's a reason in the United States we only have 27 of these. And if you look, at how many, for example, I think there have been 12,000 proposed amendments to the Constitution. That's a lot. And only 27 have passed. So right there, you have a very good reason that the ERA basically found itself in the dustbin. There's been efforts recently to try to reinvigorate it, and I believe Virginia was one of the first states to do that. So I don't want to say more except to say the issue is out there and it remains out there.
So this is from one of my students, actually. She writes, do you think women's roles as mothers have helped or hindered the ERA's chances? And then she asks a follow-up, which is, what kind of strategies have been most effective in changing men's minds?
Well, I think that one thing we've seen over, my years in law practice, and I've been at it a long time, 45 years, is that we've really seen that women can be very effectively mothers, and they can be professionals. They can be professors, they can work at Penny's, they can work at Walmart, they can work as accountants, they can be anything you want to be. So that floor of getting into the labor market has definitely been an improvement. One of the titles of my favorite book is called, It's Not the Glass Ceiling, It's the Sticky Floor. And that says it all, because the statistics and the studies show that women still hold down the fort primarily at home, even with husbands that are like mine, who are incredibly generous and supportive. I was on a panel with Justice Ginsburg once, and she said she thought the secret to our successful marriages, mine, hers, her daughter's, is that our husbands cooked. And I would certainly second that. As far as the strategy with men, it's like anything. When you have an important, logical, indisputable argument, then you hope that people will listen. And so, there would be no 19th Amendment without men. Why did they vote for it? Well, there were a lot of reasons. There were the ones out in Wyoming, and some people thought, well, we'll get more women in and then they'll vote for me in my political election. So that was one reason. And other people had not such great views. They thought, well, white women need the vote. Even so, they voted for it. And others felt it was the right thing to do. And I don't know that everybody had a little letter in their pocket, like Harry Burns, but like he said, there was a moral obligation, and he actually did something really important in his lifetime.
So we've got this question. Well, one person writes in to just say, to exclaim that you've made Wyoming very proud. So a number of people have asked this question, which is, what do you think is the most important next frontier in the women's rights movement?
Well, you know, before we get to the next frontier, I think we have to acknowledge that there are still a number of various serious issues in women's rights. So even hiring is not perfect. But I think we're also seeing that pregnancy discrimination, despite being illegal, family leave, all these issues really figure in to women's rights. And when those collide with an economy that is in distress, or with a population in distress, then I think you see some very significant issues. Well, there's now, of course, the intersection of LGBTQ rights with women's rights, and there's a lot of frontiers there to be looked at. And I think also you see a good example is in the law firms. The number of women equity partners in the major law firms has been almost stagnant in the last 20 years. It's gone up a little. At the same time, we've seen women come into law school in numbers 50% or greater. So explain that. So that remains an issue. I think also women on corporate boards remains an issue. Who's running the country from a corporate standpoint? There are some women on corporate boards, but not very many. I thought it was very interesting, the press, very positive press about Citibank having its first female executive. But you think about that, the 19th Amendment was in 1920, and then you had the Voting Rights Act, which of course was very significant for all quarters. And then you had a series of legal cases that said discrimination against women on the basis of sex in various endeavors is illegal. You had Title VII, which basically said that discrimination on account of sex also is illegal. So despite all those legislative and judicial advancements, you still have a lot of challenges. And the other thing to remember is that this needs to be in the hearts and minds of people. You can't get everything you want through legislation or a constitutional amendment or a court case. It really has to be part and parcel, I think, of the fabric of our culture. And in the same way that enough men realize this with the 19th Amendment, we need to have men joining with women to realize that for the next frontier, that we really need to be working together in terms of moving ahead on rights, gender-based rights, on discrimination, on civil rights, and other things. And so that is a cultural and societal change. It's in process, and we all hope that by the time our children grow up or their children grow up, that they'll look back and see, as I say, a much more equitable society.
This is also a question that numerous people asked. Do you have a favorite recipe in the Centennial Cookbook? And then... No, go ahead.
Well, first of all, I'm not going to say one of the justices because they grade my papers. And so I don't want to say that I would privilege one justice over another. I will say I'm a lifelong Girl Scout. It has meant a lot to me, both in terms of growing up, but also working with girls now. And I think I would perhaps say the Girl Scout cookie recipe. I want to tell you about my recipe, which is a little controversial by name. It's called Judicial Misconduct Chili. And you could feed a courthouse with this chili. Where did that name come from? Nobody knows. I've researched it, I've looked. You can find it in Australia, you can find it in Europe, but it is fantastic chili, and I've made it over the years. So just for the name alone, that was the recipe I contributed.
So I was hoping you could talk a little bit on that topic about how you think the work you've done on sort of managing the workplace environment within the judiciary relates to some of the themes you've talked about today.
Sure. You know, when the Me Too movement hit, it seemed to have been centered on Harvey Weinstein. But before long, it was everywhere. You know, it was in media, it was in Hollywood, it was in banks, it was in all kind of workplaces, and of course it was in the courts as well. So I was asked by our chief judge to do something to address this issue. And then soon after, Chief Justice Roberts appointed a national workplace committee, and I am part of that as well. And I would say we've done a lot of listening during this period, and I think we've done a lot of advancement. One, bringing the issue to the table, dramatically changing our policies. In the Ninth Circuit, we also appointed the first ever Director of Workplace Relations. And we've done a lot of listening tours. We actually did a survey of some 7,000 individuals who had worked in the Ninth Circuit. And, you know, we learned a lot. We, of course, learned that many things are perception. And we also learned that it's important to be able to talk about it. And so we've tried to provide those opportunities, both in the court, in the law schools, and in other venues. I think it is work that continues to be important. It is not a report or a fruition of policies that are just going to be put on the shelf. It's really a continuing effort. And I feel quite confident that in the federal courts and through the Chief Justice and my Chief Judge and others, that it will be a continuing effort and there'll be continuing issue on the table. I should also say a number of state courts, including in California Supreme Court, have done equally important initiatives in this work. So while many might have thought, oh, maybe the judiciary will be immune from this, we have 30,000 approximately individuals who work in the federal judiciary. So it is a major, large workplace. And we hope that some of the things we've learned might be used eventually by those in the executive branch and the congressional branch. And we're always looking to learn from others.
So somebody writes, on the subject of advice from mothers, what's the best piece of parental advice you received that made a big difference in your life?
Well, I received a lot of advice. I don't know that I always saw it as advice. I might have been a little recalcitrant to some of the things that were suggested to me. One thing I can tell you that my mother told me is she said, you can be anything you want to be. And I don't even know if I knew what that meant, but it does come back to me time and again. And some years ago, I purchased a little ceramic plaque by an artist up in Washington State. And it says, when you're out on a limb, the world is at your feet. And I would say that has been one of my guiding principles, along with my mother's advice.
So somebody's interested in what they might read if they want to learn more about how the 19th Amendment has changed the shape of voting across the country over the last century. If you have any recommendations.
Sure. The Georgetown Law Journal is a very important piece. Did we put up that slide?
Let me put it up right now.
Why don't we put it up now? This was a joint effort between the 19th Amendment Commission and Georgetown. And we commissioned this very special edition of the journal. So as I said, the conversation is in there with Justice Ginsburg. She has a lot to say on this subject, but so do the other scholars. So I would suggest reading that. I would suggest reading The Woman's Hour by Elaine Weiss. And then the final thing I'll say is that if you go to the 19th Amendment Commission website, which I think is just ambar.org/19, you see a whole host of suggested resources in the 19th Amendment arena. You can probably read from now until the next constitutional amendment gets passed and not be done reading on this subject. So those are a few of the things I would suggest and the resources that I would suggest.
So I think we have time for one more. And one person asks, what are some ways you think that we as general citizens can help promote equality for all women?
Well, you know, that question right there says it all, because it really needs to come from the citizens. And it should not be just from the legislature or the courts. So what can citizens do? Well, you can think about it in your daily life. I think, you know, the 19th Amendment gave women the right to vote. Everyone should vote, no matter what. If you look at the 19th Amendment website, we actually even have a website created by a Girl Scout for the highest Girl Scout award, the Gold Award, and she created a website on vote and what it means to vote. So I would say voting for all of us is one of the key things that we can do. We can teach our children. We can have dialogue with our neighbors. We can be Zoomed to death on all kinds of topics. And believe me, there'll be more 19th Amendment opportunities before 2020 is out. But I do think it really rests with the citizen. And in the same way, you know, the confidence in the judiciary really comes from the trust that citizens have in the judiciary as a whole. So I think all of us need to think about what do we need to do to make sure that we have trust in our communities? And what do we need to do to instill the principles in children, the principles in our neighbors, principles in law students and others that are important, because that really will be the lasting effect. I do thank all of those from the 7 decades who fought the fight. It was really amazing when you think about it. And the last thing is, guess what? They had one characteristic in common. They persevered. So thank you.
So at this point, what I really wish I could do is to lead everyone in what I know would be a standing ovation for one of the best Constitution Day lectures we have had. That was really inspiring and informative. Thank you so very much. And I'd also like to invite you to come back to Stanford under more normal circumstances. So maybe we could, so you'll have a chance to meet and mingle with the students. A large number of the people who we can't see who are out there listening are first year students here at the law school. And it would be especially nice for them to have the chance to meet you in person. So please expect an invitation just for something not as laborious as a formal lecture, but maybe more pleasant. And with that,
well, I plan to do that, Mike. And I want to say that these are first year students, and I just met before this with some of the undergraduate students. And I have had over the years and currently law clerks from Stanford. But for those of you who are first year students, I promise you, this pandemic will end someday. and I will see you on campus.
Thank you. And I'd like everyone to know that the next Constitutional Law Center event is next Wednesday during the lunch hour. We are doing two things that are related. We are having a session on what to expect if Donald Trump is reelected in terms of constitutional law in the courts, and what to expect if Joseph Biden is elected in terms of the same set of issues, in which we're inviting a supporter of each of those candidates to speak, and then on the same session with a response from a supporter of the other candidates. So this is our chance to, get beyond the rhetoric of the election and to think seriously about what these choices mean for the country. So please join us. The next one, which is the one on Trump being elected, is next Wednesday, and then the Biden election one is what, a week or so thereafter. So next
October
Wednesday
2nd.
at 12, October 2nd. Look forward to seeing you for that.